Abortion around the country and compared to the rest of the world. We take a look at reproductive rights for women in Australia. From Melbourne, you're watching The World from Below. I'm Lizzie O'Shea. Tonight we're joined by Dr Ronli Sifris and Rachel Ball. Dr Sifris has been lecturing at Monash University Faculty of Law since 2011 and is an associate of the Castan Centre for Human Rights Law. She was a Hauser Scholar at NYU School of Law and worked as a consultant with the International Centre for Transitional Justice in New York. Her recent book, Reproductive Freedom, Torture and International Human Rights, Challenging the Masculinisation of Torture, discusses restrictions on reproductive freedom within the framework of torture discourse. Rachel Ball is Director of Advocacy at the Human Rights Law Centre, where she has been involved in casework, campaigns and UN advocacy on women's rights issues, including discrimination, reproductive rights and domestic violence. We start by looking at laws surrounding reproductive rights in Australia. Rachel, here in Victoria we decriminalised abortion in 2008. What's the current situation with abortion laws here and around the country?
Well, abortion's been decriminalised, as you said, here in Victoria, also in the ACT and in Tasmania. And in the remainder of the states and territories, it still remains on the books as a crime. And in fact, it's the only medical procedure that's regulated by the criminal law rather than health laws in Australia.
So you could still be charged with an offence for obtaining an abortion in New South Wales, one of the most populous state in Australia?
You could. I mean, there are, of course, exceptions, and abortions are widely practiced across the country. The most commonly known or understood exception is where the life or health of the woman is at risk. But there are problems, obviously, around having abortion remain on the criminal law, and having those sorts of exceptions that can be open to different interpretations and cause confusion within both the medical profession and with women who are seeking abortions.
And presumably also creates issues for doctors who might be performing abortions under the shadow of the criminal law.
That's right. So it can have some real implications for access to abortion.
Ronli, what are some of the difficulties faced by women who live in states and territories where abortion is criminalised?
Well, I guess the most obvious difficulty is the fear of prosecution. And people often say, well, abortion's so widely available in Australia that doesn't really matter if it's still on the criminal law statute books. And the answer is yes, because just as recently as 2010, we actually saw a prosecution for abortion taking place in Queensland. And in that case, there was a young couple, I think they were aged 20 and 21, who got hold of the medical abortion pill RU486 and were actually prosecuted under the Queensland abortion laws for using that. And so there is a very real threat of prosecution where abortion remains part of the criminal code.
And what was the outcome in that case?
So the outcome in that case was actually that they were acquitted, but that was more because of the extremely technical reading that the judge in question gave to the Queensland law, rather than because there couldn't be a successful prosecution per se.
Looking particularly at the examples of decriminalisation in Tasmania as well, which we've seen recently, Ronli, what is your assessment of the reform to laws there? Tasmania, as you said, just recently reformed its abortion law in 2013, and that was really following on from Victoria's laws, which changed in 2008. So in many ways, the Tasmanian law was modelled on the Victorian law, but with some key differences. And one of perhaps the main key difference in the Tasmanian law to the Victorian law was in the introduction of what's called access zones. So this idea that there is actually a zone around an abortion clinic within which no anti-choice protests can occur. So to basically allow safe access for women and for people who are going with to support them, and also for the doctors and nurses and other people who work at the clinics. So that's one of the main developments of the Tasmanian law. The Tasmanian law in some ways is not as progressive as the Victorian law. For example, the Victorian law allows for abortion on request to take place up to 24 weeks gestation, whereas in Tasmania the gestational threshold for abortion on request is 16 weeks. So that's quite a big difference in that respect.
Do we know whether that's likely to have any material impact on women who are seeking abortions, whether people tend to do that past the 16-week mark very often?
For the most part, the vast majority of abortions do take place early on in the first trimester. I suppose, though, from a more philosophical perspective, it is really quite a fundamental difference in terms of who the right actually belongs to. So where abortion on request is available, there is then a clear acknowledgement by the law that the right belongs to the woman in question to make the decision, whereas once the standard changes to one of, for example, a health exception, then the decision becomes one for the doctors to make. So there are real rights implications of it, even if in practice it may not have a huge effect.
Rachel, in places where abortion has been decriminalised and there's a reduction in legal barriers, obviously, and social ones to accessing that kind of treatment, looking at this issue of access zones in Tasmania, how important is it to protect the right to access an abortion clinic? Is it a problem when the law allows them now to happen?
Yeah, certainly. I mean, the law is just one piece of the puzzle, and there are so many other pieces that need to be in place before women can actually access safe reproductive health services. And that might be because there are not many clinics around, or as you mentioned, it could be because access is purposely restricted by activists outside the clinic, and that happens across Australia. There's groups of people who stand in front of some of these clinics and they intimidate and they harass women as they come in and out of the clinics, and also staff and women's partners or friends. They'll do things like call them names, call them whores or murderers. Sometimes they physically block access, the entrance to the clinic. Sometimes they'll hand out misleading information. It's all designed to prevent women from accessing those services. And I think it's quite extraordinary that the local authorities in those areas haven't done more to prevent this from happening. I mean, if you think about it, it's not the sort of thing that would be allowed to continue outside any other sort of health clinic. And I think it's an illustration of the continuing discrimination and the stigma that attaches to abortion in Australia, even in jurisdictions where it's no longer criminalised.
And how do you balance the right of women to access abortion clinics with the right to freedom of speech, which is an issue that's raised regularly?
The activists who are trying to block access have the right to free speech, like everyone else in a democratic society, but free speech under both domestic and international human rights law can be limited when it causes harm to other people. And I think this is clearly a case where the activists, or they call themselves sidewalk counsellors, are causing significant harm to the women and staff trying to access the clinics.
Okay, we're going to take a quick break, but we'll be back to discuss conscientious objection in the context of reproductive rights. Stay with us.